tyranny really begins. It's the religious commitments of our nation that has made it the greatest nation in the world. And I've got to tell you, those of you who vote against this amendment are playing with fire. Those of you who vote against this amendment are ignoring the Constitution. Those of you who vote against this amendment are wrong. Mr. President, I yield the floor.
Mr. President.
Senator from Colorado is recognized.
Thank you, Mr. President. And I want to, since he's on the floor, recognize the senator from Utah and his extraordinary service in the United States Senate. We don't agree on this issue, but he's done a tremendous job for the people of Utah over many years. I wanted to rise to talk a little bit about the amendment that we're considering that would allow all employers and insurers to deny coverage, particularly for women, on any health care procedure or service they object to, not the women, but the employers of the insurance companies, on moral or religious grounds. The first thing I want to do, and I haven't been around here for a long time, but I wanted to first observe what context we're discussing this in and we're debating this amendment. We've devoted extensive floor time on this amendment about contraception and lack of coverage for women's health care in the context of a job creation bill, in the context of the transportation bill. This is the bill. This is the bill that is on the floor of the United States Senate right now. And the title, it says, a bill, Senate 1813, a bill to reauthorize federal aid highway and highway safety construction programs and for other purposes. I would have thought those other purposes would be related to transportation, to transit, to job creation in the United States. I don't think the other purposes that are talked about in this bill have anything to do with contraception or women's health. But that's what we're spending our time debating this week on the floor of the Senate, instead of passing this transportation bill and putting people in this country back to work. How is this conversation relevant to job creation or to infrastructure? It's not. In my home state of Colorado, Mr. President, I have held hundreds of town hall meetings in red parts of the state and blue parts of the state. And I don't remember a single time this issue, the issue that is of concern with this amendment, has been raised by anybody in 3 years. I can tell you what people are talking about in Colorado, Mr. President. They want to know why we aren't spending our time working on how to create more jobs for them, more jobs in the 21st century in this country, or how to fix this nation's debt or deficit, or how we pass a bipartisan transportation bill that creates immediate jobs and fixes a crumbling infrastructure while maintaining the infrastructure assets our parents and grandparents had the thoughtfulness to build for us. Another case where political games are risking our ability to provide more opportunity, not less, for the next generation of Americans, something that every single generation, until this one, at least of politicians, has treated as a sacred trust. And instead, over the last several weeks, we've continued to debate about women and whether they should have access to the health care services they need and whether they should be the ones that are able to make the decisions about the health care services that we need. And we sit here and wonder why the United States Congress is stuck at an approval rating of 11%. Maybe it's because we're talking about contraception in the context of a transportation bill. Mr. President, I have a wife and 3 daughters. They're 12, 11, and 7. There are a lot of women in my life telling me what to do every minute of every day and during the week, and thank goodness for that. And one thing I know is they don't need to be told by the government how to make their own health care decisions, nor do the 362,000 Colorado women that would be affected immediately if this amendment passed. This amendment is written so broadly, Mr. President, that it would allow any employer to not deny any health service to any American for virtually any reason, not just for religious objections. Women could lose coverage for mammograms, parental care, prenatal care, flu shots, to name only a few essential services. And yes, the right to make decisions around contraception and their own reproductive health. Mr. President, my state, the great state of Colorado, is a third Democratic, a third Republican, and a third independent. And I can tell you that the last time there was an initiative on the ballot in my state to let the government intervene in women's health care decisions, it was defeated by 70% of the voters. 70% of the voters said, you know what, we'd rather leave these decisions to women to make for themselves. And that's what my daughters want as well. People are speaking loud and clear on this issue all across the country. These aren't the issues we should be debating right now. We need to be having the conversations people are having at home in my town halls instead of distracting them with politics. How do we create more jobs? How do we reform our entitlements so that Medicare, Medicaid, and Social Security are here for our grandchildren and for our children? How do we create an education system that's training our people for the 21st century? How do we assure poor children in this country that they can have a quality education, make a contribution to this economy? So I urge my colleagues to oppose this amendment and help us get back on the road to passing a bipartisan transportation bill that will create new jobs and make substantial improvements in our economy and infrastructure. There's a time to debate this, but that time is not now when we're having this infrastructure discussion. We're having this transportation discussion. I urge my colleagues to support the rights of women all across this country and their families and reject this amendment. Thank you, Mr. President. I yield the floor.
Mr. President. Senator from Missouri is recognized.
Thank you, Mr. President. Mr. President, the reason that this amendment is being debated right now is that the administration issued an order that's just unprecedented. Now, it's unprecedented because the mandate provisions of the health care bill are also unprecedented, but that's the reason we're debating this now. The administration brought this up. I'm still amazed by the fact that the administration wouldn't have excluded all of at least the faith-based institutions from their order. I mean, the Catholic hospitals, the Baptist universities, the Catholic schools of all kinds, the Christian schools of all kinds, the Muslim daycare center. Why wouldn't they have exempted these people? Now, they say, well, we exempted the church itself, as if the work of the church or the character of the church or the faith distinctives of the church, the synagogue, the mosque, are only what happens inside that building. You know, there's a reason that we have so much of our health care, our social services provided by faith-based institutions, and one of the reasons is that those faith-based institutions want those institutions that they fund, they support, they encourage to reflect their faith principles. And what's wrong with that? There are really a couple of issues here. One is the separation in the President's mind from the work of the church or the synagogue or the mosque and the building itself. And it's impossible to separate those two things. Otherwise, you just have another Christian school that happens, another high school that has a chaplain. You don't have a Christian high school. Or you have another hospital that's run by the Sisters of Mercy. You don't have a Catholic hospital because you've decided you're going to define the character of what that hospital stands for and what they provide. Now, the administration recently took a Lutheran school to court. The EEOC took a Lutheran school to court and asserted that that school didn't have any special constitutional protections as to how they hired people. And you could have heard all these same kinds of arguments. Well, they'll discriminate against people. They won't hire people that otherwise should be hired. They won't make accessibility to the handicapped. They won't do. You hear all of that sort of thing, none of which would have been true. And the Supreme Court voted 9-0 that the administration was wrong. And you can try all you want to separate these two issues, but they don't separate. They're both fundamental First Amendment issues. Let's talk about some of the things I've heard here this morning. My good friend Senator Bennett from Colorado said if this amendment passed, 362,000 Colorado women would lose their current their current health care services. Now, why would that be the case at all? This amendment does nothing to modify state or federal laws that are now in effect. If you've got those services now, there is nothing in this amendment that would change the world that we live in right now. People have the same protection today to exert their religious views in their health care policies that they provide as an employer that they would have if this amendment passed. They have those protections now. They would not lose those rights. It doesn't modify any state or federal law, and there are plenty of federal laws. There's a federal law on pregnancy discrimination that says pregnancy-related benefits cannot be limited to married employees. Now, that law doesn't go away if this amendment passes. State laws that require things to be in health care policies, if you have one, don't go away if this amendment passes. It only amends the new mandate provisions of Title I of the new health care law, the health care law that has received so much controversial attention for good reason, and this is one of those reasons. Supplying the respect for religious beliefs and moral convictions is already part of the federal health programs of all kinds. It just doesn't happen to be in the new law. There is no health care law since 1973 that doesn't have these provisions in this bill that are part of the law. The law is there now, Mr. President, and the world doesn't change. No Colorado woman will lose any health care benefits they have today if this amendment passes. No New Jersey woman will lose any benefits they have today if this amendment passes. Regarding any health care service that people may be worried about, we ask one question. Are people allowed to exclude this service from their health care benefit under current state or federal law? And if they're not allowed to exclude it under current state or federal law, they wouldn't be allowed to exclude it if this amendment would pass. If they're not allowed to exclude it, they're still not allowed to exclude it under this amendment. And if they are allowed to exclude such service, why haven't the critics been protesting before? This amendment doesn't change anything in the law today. So why haven't we heard these speeches before about how the law doesn't protect employers from deciding not to offer this or not to offer that? In fact, this makes it much more difficult to exclude services than it is now. Much more difficult to exclude services than it is now. And in fact, it allows for an actuarial equivalent to have to be added to a policy if you take something away. Now, that means there's no financial reason. There's no financial reason to exclude a service. Because if you exclude a service because you believe it's the wrong thing, the Secretary of Health and Human Services has the power to say, you have to come back and include a new service that we didn't require of equal value. Now, I assume everybody on the other side of this debate would think that employers must be motivated to exclude these services if they're not legitimate religious belief and moral conviction, that they must exclude them because they'd save some money. Well, we don't allow them to save money. So there's no reason. The Secretary of Health and Human Services can say, okay, you're going to exclude that, but you have to include something we didn't require of equal value. That means something that's going to be equally used. That means something that's going to be equally costly to the employer. So why would the employer do that? I mean, why aren't we hearing all these stories now about how employers are not? Why did the 200,000 women that have these health services today, I think it's 20 million. Why do they have those services? There's nothing in the law that requires it. This law doesn't change the laws today. Now, from the point of view of having a political discussion instead of a discussion about what the amendment does or why it's consistent with what we've always done, I think The other side's done a great job of that. But consistently, we have protected this principle of First Amendment freedoms. In fact, in 1994, in the bill that Mrs. Clinton, the First Lady at the time, worked so hard for, that was introduced here by Senator Moynihan, here's what it said. Nothing in, and this was a bill that also would require people to provide insurance. You know, we don't have much about insurance because we haven't required people to provide it before. There's some federal health benefits about insurance I may talk about in a minute that also are protected. But this was a bill that required people to provide insurance. And Senator Moynihan said in his bill in 1994, less than 20 years ago, nothing in this title shall be construed to prevent any employer from contributing to the purchase of a standard benefits package which excludes coverage for abortion and other services if the employer objects to such service on the basis of religious belief or moral conviction. Now, the most amazing thing about this whole debate to me is that in 20 years, this has gone from language that would be in what was considered the most progressive, liberal health care bill that had ever been offered by one of the most respected senators by Americans of all political philosophies, but most agreed with by Americans of a more liberal political philosophy, that he would just put that in the bill. And I've asked, is there any indication in the debate on that bill that this was a big item? And the answer I hear is no, it wasn't a big item because it was part of who we are. It was part of what we'd been as a nation. It was part of protecting the First Amendment. And this amendment does not mention any procedure because I don't know what kind of, and nobody knows what things might be in some future date religious to somebody's, or offensive to somebody's religious beliefs. But you have no financial reason to not provide a service, so the only reason you'd really have under this amendment would be a true moral objection. And I had some immediate initial hesitation myself. I said, okay, I understand the faith-based institutions. I used to be the president of a Christian university, and so I understand why it's important that those institutions keep their faith-based distinctives. But what about other employers? And frankly, I didn't have to think about that very long to realize if you are of a faith that believes that something is absolutely wrong, as an employer, why would you want to pay for that? You believe this is a wrong thing to do. Why would you want to pay for that? And the language of equivalency in this bill means if you choose not to pay for that, the Secretary can say, okay, come up with something else that would be equally used and equally valuable that you would pay for. So there's no financial reason not to do it. The only reason not to do it is you truly believe it's a wrong thing to do. Now, surely every person in the Senate has at least one thing that, because of religious reasons, they believe is wrong to do. Do you want to be forced by the government to be a participant in that wrong thing? The things we're talking about here today, in my particular faith, I'm not opposed to all these things that the President said he would require. But that doesn't mean I should be any less concerned about people who legitimately, week after week at their place of worship, express this to be something that you should not participate in. Now, if the congregants want to go on their own and figure out how to participate, that's one thing. If they want to go on their own and provide insurance to their employees that include these things that they just heard at church are wrong to do, that's another thing. But if they want to say, look, I'm not going to do that, but under the new mandate, we don't do anything here that eliminates the mandate. There's still a mandate. Under the new mandate, I'm not going to do that, but I'm going to have to add something to the policy, to the mandate, that would be of equal financial value, of equivalent value. So the only reason to object, Mr. President, is you believe it's wrong. And that's what the First Amendment is all about. That's why, consistently, through employment law, we've protected, even though the administration lost a 9-0 case trying to interpret that the same way they want to interpret this. But no, the government knows best, and if you're allowed to, you'll abuse the hiring situation Now they say if you're allowed to, you'll abuse the health care providing situation. I think we've taken away the financial incentive to do that. I believe what this does is protect First Amendment rights. The first freedom in the founding documents is freedom of religion. And we have protected it over and over and over again. Every member of this Senate who's been here in any recent time, except the very newest members, have voted for bills that had this language in them, whether it was the Clinton administration, whether it was the Moynihan proposal, whether it was the Patient's Bill of Rights, or the religious freedom law. It was all there. Now, I think it's to come up with all these cases that they wouldn't treat prenatal care or might not treat cancer. Why would they not do that? Why would they not do that? If they don't treat that, they have to pay for something else of equal value. Look at the very last provision of this amendment. So there's no financial reason not to do this. The only reason is that you believe it is against your religious views. And the phrase we use in this bill is exactly the phrase that Senator Moynihan used. It's exactly the phrase that Frank Church used. It's exactly the phrase that people on the floor at this moment voted for when they said we don't want people to have to participate in capital punishment or prosecuting crimes where capital punishment is a possibility because of religious belief or moral conviction. It was good enough for everything up until now, including this principle, until we get to 2012, and suddenly we have all these reasons that people can't make faith decisions that relate to providing health care to employees. And I disagree with that. I think the First Amendment protects that. I believe if and when, and if this rule goes forward, it will go to the Supreme Court, it'll be something close to that 9-0 decision on hiring rights. There is no difference in the principle here. And again, I'd say look at the last section of this bill if you believe that employers are going to do this to save money. And otherwise, what motivation do they have besides the moral conviction and religious belief that is protected by the First Amendment? And I hope my colleagues will read this bill carefully, will understand that there's no protection given, that no protection currently in the law is taken away by this bill. If you have a right now, you would still have it if this amendment passed. And to argue otherwise just denies the facts of both people who have coverage today and 220-plus years of constitutional protections in the country. Read the bill. It may not change any minds today, but this issue will not go away unless the administration decides to take it away by giving people of faith these First Amendment protections.
Senator from Washington is recognized.
Mr. President, I rise to join this debate today, and I certainly respect the senator from Missouri for his views and for his own interpretation of what he thinks his amendment does. But I couldn't disagree more on what the amendment says, what the amendment will do, and what the process has been for us to get to this point. I mean, we're down here, and I know my own office, myself, my focus is on our economy and getting our country moving again and focusing on jobs. And so when I see a transportation bill that is now mired in this debate, I ask myself, how much more time are we going to waste debating and redebating an issue that we've been debating? I know that some people think that this is an important debate related to transportation, but it seems as if the other side of the aisle, in all the discussions we've been having for the last year about jobs, about appropriations bills, about the debt ceiling, about moving forward on reconciliation, all come down to one thing. Let's get rid of reproductive health care for women. In February of last year, they introduced a bill, H.R. 1. They said, let's defund Planned Parenthood. Then later in April came a big moment of, are we going to move forward with a continuing resolution, and it was all brought to a halt until we could have a vote on defunding Planned Parenthood. And then we had another vote on it in the latest discussions about the payroll deal. There was discussions about whether a rider was going to be in there that cut women's reproductive health care access. And appropriations bills just last December, same issue. Every step of the way, it seems as if there is an assault on women's reproductive choice and having access to health care. So I know my colleague from Missouri thinks that this issue might just be about something the administration's done in the health care bill, but his party is making everybody in America believe that we can't get our economy going and balance our budget and deal with our deficit unless we defund women's health care choices. And nothing could be more incorrect about that logic. We are holding up the business of America just for these votes on basically curtailing rights to access that women already have. So, Mr. President, it is so frustrating to think that we would be going backwards on this. And I applaud the chair of the Transportation Committee because she's worked hard on this legislation. It's 30,000 jobs in the state of Washington by the Department of Transportation's estimates. I know it's going to help save about 1.8 million jobs and create another million jobs on a national basis. And so I certainly want to get to the job at hand. And when I think about the 435,000 Washington women who would be affected by the Blunt Amendment by curtailing their access to health care, and while some people think it's about contraceptives, which it is about that, but it's also about breast cancer screening, and we have one of the highest rates of breast cancer in the country, so we want to make sure that we get those screenings done, about wellness exams, about diabetes screening, about flu shots, about vaccination, about mammograms, about cholesterol. We're having this debate today, instead of talking about transportation infrastructure, about defunding these vital programs. Now, the reason why I say this is so important to us and so important to us in Washington State is because we've been having this debate. We've been having this debate since almost, I think, 2001, 2002, on the Bartell drug decision. And so my colleague who says that, well, these businesses wouldn't dare do anything based on cost under my amendment, I think all he has to do is look at the federal cases that were brought against major employers like Walmart, like Bartell's, like Daimler Chrysler, and other organizations who weren't providing full reproductive choice for women and discriminating against them in their health care benefits. And a federal law, a federal statute was used to say that these practices were discriminatory. So the same debate we're having here today the courts have found that you cannot use these principles to discriminate. It is a violation of the Civil Rights Clause. And so while I know my colleague thinks that this is a new debate, it's not a new debate. It's a debate that has been had in America among states, and courts have used federal statutes to protect the rights of women. So now I see that we're going to have this debate today, and I ask my colleagues, how many more times this year are we going to interrupt the business of the Congress on things like transportation, on infrastructure, to have a debate that has already been settled? And I know my colleague thinks that the amendment is very narrowly written. It's not. I don't think that's the interpretation of any legal mind, that it is narrowly written. It will affect and give employers the right that courts have already said they don't have the right to discriminate. It will reopen the cases of those large employers who have already been found against and say to them, yes, you can come up with a reason and curtail access to preventive health care for women that is so needed at this time. So I ask my colleagues to turn down this amendment, and I ask my colleagues on the other side of the aisle, let's get at the business at hand and focusing on our economy, focusing on jobs, and stop making women's health care a scapegoat for what you think is wrong with America. It's actually what's right with America, and let's focus on jobs. Thank the President. I yield the floor.
President.
The senator from Maine is recognized.
Thank you, Mr. President. Mr. President, I have always been a very strong proponent of family planning programs and of measures to promote and protect women's health. Like many Americans, however, I was very concerned in January when the Department of Health and Human Services issued a final regulation to require religious universities, hospitals, charities, and other faith-based organizations to pay for health insurance that covers contraceptives and sterilizations regardless of the organization's religious beliefs. I believe that such a mandate poses a threat to our religious freedom and presents the Catholic Church and other faith-based organizations with an impossible choice between violating their religious beliefs or violating federal regulations. In February, President Obama announced what he termed an accommodation that would require insurance companies rather than religious organizations to provide these services. But as I read the details of that accommodation, it became very clear to me that many parts of the plan remained unclear. A key issue, for example, revolves around self-insured religious-based organizations. There are many Catholic hospitals and universities that are self-insured and thus act as both the employer and the insurer. A very important issue is how the rule would treat these self-insured faith-based organizations. But the rule was totally unclear. It said that the department would just continue to work with non-exempted, non-profit religious organizations. So in an attempt to clarify this critical issue, I sent a letter to Secretary Sebelius asking for specific clarification on how faith-based organizations that are self-insured and thus act as both the insurer and the employer would be treated. Would they have their rights of conscience protected? This was not a complicated question. It was a very straightforward question. And frankly, the answer to the question was going to determine my vote on this very important amendment. Sadly, the administration once again skirted the answer. In her response, Secretary Sebelius simply said that the President is, quote, committed to rulemaking to ensure access to these important preventive services and fully insured and self-insured group health plans while further accommodating religious organizations' beliefs, end quote. What does that mean, Mr. President? And I would ask unanimous consent that both my letter to Secretary Sebelius and her reply be put in the record at the conclusion of my remarks.
Without objection.
This was very frustrating to me. I asked a key question and I could not get a straight answer. It also demonstrates many of the problems associated with employer mandates. I also think this is a sad. I would ask permission to have two additional amendments.
Sir, objection.
Two additional amendments.
So ordered.
Thank you. I believe that the sponsor of this amendment is completely sincere, and I want to make that clear. But this issue has become a sad example of election year politics. I believe that a good compromise could have been reached and should have been worked out. For example, in Maine, state law requiring contraception coverage includes a specific exemption for religious employers such as churches, schools, and hospitals. Surely we could have reached a similar accommodation. And unfortunately, what we're left with is an issue that's important and that too many people, including this administration, are playing politics with. Since I could not and did not receive a straightforward answer to my question about protecting self-insured, faith-based organizations, I feel that I have to vote for Senator Blunt's amendment with the hope that its scope will be further narrowed and refined as the legislative process proceeds, and recognizing that state laws will not be preempted. I do this with a lot of conflict because I think the amendment does have its flaws, but when the administration cannot even assure me that self-insured, faith-based organizations, religious freedoms are protected, I feel I have no choice. I hope that the amendment will be refined, and I also hope that the Senate will move forward to address the many important pressing issues facing our nation and stop engaging in what is clearly an election year ploy. Thank you, Mr. President.
Senator's time has expired.
President.
Senator from Vermont is recognized.
President, I ask consent to speak for up to 5 minutes on the Blunt Amendment.
Without objection, so ordered.
Mr. President, in Vermont and all across this country, there is growing frustration that members of Congress, mostly men, I should add, are trying to roll back the clock on women's reproductive rights, in this case, the right of women to receive contraceptive services through their insurance plans. This attack is grossly unfair, and I hope that men will stand with women in the fight to protect this very basic right. And let me add my strong belief that if the United States Senate had 83 women and 17 men rather than 83 men and 17 women, my strong guess is that a bill like this would never even make it to the floor. 2 years ago, Congress passed a health care reform that will expand health care access for over 30 million Americans who are uninsured, as well as millions of Americans who are covered through their employer. This bill is by no means perfect. I would go further, but it is a step forward in allowing us to catch up with the rest of the industrialized world that guarantee health care to all of their people as a right. Unfortunately, the amendment we are discussing today, Senator Blunt's amendment, would undermine much of the progress being made for women's health care through a new version of a so-called conscience exemption. Not just content to attack women's rights, Mr. Blunt's amendment would go even further and seeks to deny patients access to any essential health care service their employer or insurance company objects to, based simply on the employer's, quote, religious beliefs and moral convictions, end of quote. This amendment would especially have an adverse impact on women's health. Starting in August, women enrolled in new plans will have access to a range of preventative services at no cost. But allowing the kind of extreme so-called conscience clause included in the Blunt Amendment would allow an employer to refuse coverage of contraceptives, annual well-woman visits, or even treatments for both genders like mental health services or HIV/AIDS treatment based not on a doctor's recommendation but on the religious belief or moral conviction of a person's employer. This is an absolutely unprecedented refusal right. The Blunt Amendment must be defeated. Mr. President, I yield the floor.
Mr. President.
Senior senator from Massachusetts is recognized.
Mr. President, I ask consent to speak up to 8 minutes on the amendment.
Is there objection? So ordered.
Mr. President, this is obviously a difficult time in our politics. We're all familiar with that, the polarization. It's a difficult time for the Senate in particular because over the years, this has been a place where we've prided ourselves on working, and I mean really working, to find ways to avoid the kind of polarization that we see today and actually to find the common denominator on a number of sensitive issues. I think our friend from Maine, Senator Snowe, spoke for many of us this week when she talked about the, quote, my way or the highway approaches to partisan politics that have made it harder for people to work with each other and to actually get things done. I would never speak for her, but I think given her diagnosis of what's wrong with the Senate today, as she has made a decision not to run for re-election, I think that the amendment that we're debating here today, frankly, is Exhibit A. 2 years ago, many of us voted to end an era where many Americans felt that women in particular, but poor people and others also, but women in particular, were put into a position of a second-tier status with respect to the access to health care in America. There were so many discrepancies. Just one example, for instance, that was an era before the reform that we passed where Viagra was covered for men at no cost by insurance companies, but contraception, which 99% of American women use, was not covered. So we addressed this issue in the reform that we passed, and the Congress sent it to the President signed it. The administration then took the time appropriate, recognizing the difficulty of implementing some of this. They allowed for a time period in order to be able to work through the rules. Now, when they did come out with the first rule, I regret they came out with a rule that many of us felt, I felt, and shared with others in America, a sense that it was not going to work. There was a firestorm in the country over that for a brief period of time, and I spoke out in our caucus, and I said that I thought there was a better way to try to deal with that created a balance between the First Amendment requirements and the needs of people to be able to have access and be protected. I didn't think it was, and I don't think today it is right to force a religiously affiliated institution to pay for contraception if it violates fundamental religious beliefs. I am glad to say that the administration, the White House, which I think, perhaps hadn't been able to see all of the implications of what had happened at that point in time, quickly moved immediately to recognize, indeed, the rule was not proposed as it ought to be, and they changed it. They responded. That was the right decision. And this week, Secretary Sebelius has made it clear that they are still working with the faith community on a final rule that will address the concerns of my church and of other institutions which are self-insured. But, with respect to what the senator from Maine, Senator Collins, just said a few minutes ago, with all due respect, Secretary Sebelius said publicly after the Senate Finance Committee hearing on this subject, on the budget, she said, whether it's an insured plan or self-insured plan, the employer who has a religious objection doesn't have to directly offer or pay for contraception. I take issue. I believe the letter that the senator received actually addresses this question and says that they are working with the community, as I believe they ought to be, in order to come up with a means of guaranteeing that self-insurance will be protected, as I believe it ought to be protected. But I don't believe that we ought to embrace the Blunt Amendment as this broad-based opening of Pandora's box amendment that carries with it all kinds of other risks and potential mischief. And we don't have to do that in order to protect a self-insurance here. So I think it's important to work together with patience to try to find a way to do no harm, if you will, to the Constitution or to the rights of women in this country to access health care. I believe the spirit of the amendment that is in front of us today, not intentionally. I know that the senator from Missouri acts in good faith personally on this, and I respect that. But the language, as language is always important, critical in legislating, the language is overbroad. And if there's one thing I know after 27 years of legislating here is when you're writing legislation, it is critical to understand the implications of the language that you use. Precision matters. This amendment opens up the potential for overly broad and vague exceptions that could allow children to be denied immunizations. It could allow companies. A company is quite different from an individual's right to protect under the Constitution, but it would allow a company to actually object to mental health services. It could allow you could allow for the denial of HIV screenings because people think that somehow that's a disease that belongs to a category they object to in terms of social life and structure in America. It would allow potentially the objection of maternity care for single mothers because people have an objection about a single mother being pregnant, having a child. I mean, there are all kinds of mischief that could be implemented as a consequence of people's assertion of a belief that is not in fact covered under the First Amendment, but which as a result of the language in this amendment could be swept into some claim. And I don't think we should do that. That is not good legislating. That is dangerous. Now, I was interested to hear the minority leader here this morning assert some things about the First Amendment. I think they are absolutely incorrect, Mr. President. The First Amendment is a guarantee that religious liberty will be protected in America and that the government will not institute one religion or another or establish a religion for the nation. And it also says that no religious view will be imposed on anybody. The Blunt Amendment is, in fact, an assault on that protection of the First Amendment because it imposes one view on a whole bunch of people who don't share that view or on those who want to choose for themselves. The Affordable Care Act and the President's compromise and the final rule leave all of the existing Conscience Clause provisions in place. It doesn't change them at all, while adding additional protection for churches and for religious organizations. The administration's compromise regulation, endorsed by the Catholic Hospital Association and other religious organizations, maintains conscience protections so that any religious employer with protections to coverage of contraceptive services will not be required to provide, refer, or pay for these services. Furthermore, all churches and houses of worship are exempt from the compromise regulation. In fact, the Women's Law Center pointed out, makes it clear, and I quote, "Under current law, individuals and entities who wish to refuse a role in abortion services are protected by 3 different federal laws." Mr. President, I would ask the unanimous consent that the balance of my statement be placed in the record as if read in full.
Without objection, so ordered.
I thank the Chair. And I'd simply close by saying that the Senate should not rush to undercut the protections already in place and which ultimately would undermine the teachings of my church, which argue that social conscience and values ought to be really primarily established by caring for our sick. And this would, in fact, deny that to some degree.
Senator's time has expired.
Mr. President,
The senator from California is recognized.
I would ask that I be allowed to speak for 5 minutes and then Senator Murray conclude our side with 5.
Without objection, so ordered.
Mr. President, I have news for supporters of the Blunt Amendment. We were not born yesterday, and no matter how much you say this is nothing more than a restatement of old laws, the facts just are not with you. We have never had a conscience clause for insurance companies. And if you wanted to give them a chance to say no, A lot of them don't have any consciences. They'll take it. And this is what Blunt does. It allows any insurance company that doesn't want to provide a service, maybe an expensive service, to say, oh, I meant to tell you I have a moral objection to this. What a situation. How many people have struggled with their insurance companies to get them to cover what they've paid for years and years and years, only to have the insurance company say, sorry, sue us. Now, Mr. Blunt is giving insurance companies a way to say, oh, we really feel sorry that you have cancer. We're really sad that you have diabetes. We're really torn apart that you might have a stroke. But you know what? We have a moral objection to the kind of therapies that they're out there today, so we're sorry. That's what the Blunt Amendment does. And if you think I'm making it up, let's look at the words in the Blunt Amendment. They're right here. They're right here. And so the senator from Maine can say whatever she wants about it. The senator from Missouri can talk about what he wants to. The fact is, they say that if you deny any coverage from the essential health benefits package or the preventive health package, it's fine as long as you hide behind, my words, a moral objection. So this started out with birth control. And there was a hearing over in the House that is an iconic picture that will last through my lifetime and yours. Mr. President, here is a photograph of a panel discussing women's health care over in the Republican House. Women's health care. Do you see one woman there? I don't. They're all men. And these men are waxing eloquent about birth control and the fact that, oh, it's just a moral issue with them, and they don't think women should have the right to have it. Not one of them suggested that men shouldn't have their Viagra, but we'll put that aside. We'll put that aside. Not one woman was called. And when a woman raised her hand in the audience and said, I have a very important story to tell about a friend of mine who lost her ovary because she couldn't afford birth control, would have controlled the size of the cyst on the ovary, you know what Mr. Issa said over there? He said, you're just not qualified. You're not qualified to talk about women's issues. I guess only men are qualified to talk about women's issues. And we have men on the other side of the aisle here, for the most part, with a little assist, telling women what their rights should be. I cannot believe this battle on a highway bill, on a transportation bill, where 2.8 million jobs are at stake. We have been diverted with this amendment about women's health. And look at the different important benefits that any insurer or any employer could walk away from, because if this amendment passes, they have the right to do it. They would no longer have to cover emergency services, hospitalization, maternity care, mental health treatment, pediatric services, rehabilitative services, ambulatory patients services, laboratory services. They would no longer have to offer breast cancer screenings, cervical cancer screenings. All they have to do is say, oh, I'm really sorry. We believe prayer is the answer. We don't believe in chemotherapy. We believe that, you know, if someone is heavy and they're obese and they get diabetes, we have a moral objection to helping them because, you know what? They didn't lead a clean life. So they could deny any of these things: flu vaccines, osteoporosis screening, TB testing for children, autism screening. So I would say, in conclusion, vote down this dangerous amendment. Vote it down. We'll have a motion to table and stand for the women and the families of this nation, and let's get back to the highway bill. Get rid of this thing. I yield the floor.
Mr. President.
The senior senator from Washington State is recognized.
Mr. President, thank you so much. And I want to thank Senator from California and the many senators who stood up proudly to fight for a woman's right to make her own health care decisions. Certainly in this year of 2012, after decades of fighting to make sure that women have the rights and opportunities to be whoever they want and to make their own health care choices, this vote today is an affirmation of that if we can beat back this blunt amendment. We are at a very serious time in our nation's history. Our economy is struggling. We are getting back on track. Millions of families get up every day and are concerned about whether they can afford their mortgage or send their kids to college. I have to tell you, millions of women in this country did not think they would have to get up this morning and worry about whether or not contraception would be available to them, depending on who their employer was. Mr. President, this is a serious issue. We've heard a lot of rhetoric about what the blunt amendment is. My colleague from California just described it to you. It is terrible policy. It will allow any employer in America to cut off any preventive care for any religious or moral reason. It would simply give every boss in America the right to make the health care decisions for their workers and their families. It is a radical assault on the comprehensive preventive health care coverage that we have fought so hard to make sure that women and men and families across this country have. If this amendment were to pass, employers could cut off coverage for children's immunizations if they object to that. They could cut off prenatal care for children born to unmarried parents if they object to that. Mr. President, the American people are watching today. Young women are watching today. Is the United States Senate a place where their voice will be heard and their rights will be stood up for? We have watched this assault on women's health care for more than a year now. When a year ago, almost at this time to this day, we were working to make sure we kept the government open by putting together our budget agreement. In the middle of the night, all the numbers were decided. All the issues were decided. We were ready to move forward within hours to make sure that our government did not shut down. What was the last issue between us and the doors of this government closing? The funding for Planned Parenthood. I was the only woman in the room. And I stood up with those men and I said, no, we will not give away the funding for this over this budget. And the women of the Senate the next morning stood tall. We gathered all of our colleagues together. We fought back. We won that battle. But those who are trying to take away the rights of women and to make their own health care choices and to have access to contraception in this country today have been at it every day since. We are not going to allow a panel of men in the House to make the decisions for women in this country about their health care choices. We're not going to allow the blunt amendment that is before us today to take away that right. We believe that this is an important day. And in fact, Mr. President, this happens to be March 1st. It is the beginning of Women's History Month in this country. Let us stand tall today in this moment of history and say the United States Senate will not allow to let women's health care choices to be taken away from them. Mr. President, I urge my colleagues to vote with us to table the blunt amendment and to tell women in this country everywhere that we stand with them in the privacy of their own homes to make their own health care choices. Mr. President, has all the time expired on this amendment?
All time has expired.
Mr. President, I move to table the blunt amendment. I ask for yeas and nays.
Is there a sufficient second? There appears to be. Clerk will call the roll on tabling the blunt amendment.
Mr. Akaka, Mr. Alexander, Ms. Ayotte, Mr. Barrasso, Mr. Balkis, Mr. Begich, Mr. Bennett, Mr. Bingaman, Mr. Blumenthal, Mr. Blunt. Mr. Bozeman, Mrs. Boxer, Mr. Brown of Massachusetts. Mr. Brown of Ohio.
Aye.
Mr. Burr. Ms. Cantwell. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Chambliss. Mr. Coates. Mr. Coburn. Mr. Cochran. Ms. Collins. Mr. Conrad. Mr. Coons. Mr. Corker. Mr. Cornyn. Mr. Crapo. Mr. DeMint. Mr. Durbin. Mr. Enzi. Mrs. Feinstein. Mr. Franken. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Mrs. Hagan. Mr. Harkin. Mr. Hatch. Mr. Heller. Mr. Hoven. Mrs. Hutchison. Mr. Inhofe. Mr. Inouye. Mr. Isaacson. Mr. Johans. Mr. Johnson of Wisconsin. Mr. Johnson of South Dakota. Mr. Kerry. Mr. Kirk. Ms. Klobuchar. Mr. Cole. Mr. Kyle. Ms. Landrieu. Mr. Lautenberg. Mr. Leahy. Mr. Lee. Mr. Levin. Mr. Lieberman. Mr. Lugar. Mr. Manchin. Mr. McCain. Mrs. McCaskill. Mr. McConnell. Mr. Menendez. Mr. Merkley. Ms. Mikulski. Mr. Moran. Ms. Murkowski. Mrs. Murray. Mr. Nelson of Nebraska. Mr. Nelson of Florida. Mr. Paul. Mr. Portman. Mr. Pryor. Mr. Reed of Rhode Island. Mr. Reed of Nevada. Mr. Risch. Mr. Roberts. Mr. Rockefeller. Mr. Rubio. Mr. Sanders. Mr. Schumer. Mr. Sessions. Mrs. Shaheen. Mr. Sanders, Mr. Schumer, Mr. Sessions, Mrs. Shaheen, Mr. Shelby, Ms. Snow, Ms. Stabenow, Mr. Tester, Mr. Thune, Mr. Toomey, Mr. Udall of Colorado, Mr. Udall of New Mexico, Mr. Vitter, Mr. Warner, Mr. Webb, Mr. Whitehouse, Mr. Wicker, Mr. Wyden. Senators voting in the affirmative: Akaka, Blumenthal, Boxer, Brown of Ohio, Cantwell, Cardin, Coons, Durbin, Franken, Harkin, Inouye, Levin, McCaskill, Merkley, Mikulski, Murray, Reed of Rhode Island, Reed of Nevada, Sanders, Snow, Tester, Udall of Colorado, Warner. Mr. Wyden, aye. Senators voting in the negative: Alexander, Ayotte, Blunt, Casey, Chambliss, Coates, Collins, Corker, Cornyn, Crapo, Grassley, Hutchison, Isaacson, Johans, Johnson of Wisconsin, Kyle, Manchin, McCain, McConnell, Murkowski, Nelson of Nebraska, Hall, Roberts, Toomey, Wicker. Mr. Coburn, no. Mr. Nelson of Florida. Mr. Nelson of Florida, aye. Mr. Rockefeller. Mr. Rockefeller, aye. Mr. Vitter. Mr. Vitter, no. Mr. Brown of Massachusetts. Mr. Brown of Massachusetts, no. Mr. Lee. Mr. Lee, no. Mr. Bozeman. Mr. Bozeman, no. Mr. Kerry. Mr. Kerry, aye. Mr. Rubio. Mr. Rubio,